Okay, welcome. Good to see you all. The first case is number 51, People versus Avery Pettigrew.
Ready for the court, please?
Counsel, you want any rebuttal time?
Yes, if I could save 2 minutes for rebuttal.
2 minutes. Great, you've got it. Go ahead.
Good afternoon. My name is Nancy Little. I represent appellant Avery Pettigrew in this case. The issue in this SOAR appeal is whether appellant was properly assessed 30 points under Factor 1 on the risk assessment instrument. Specifically, whether the people proved by clear and convincing evidence that he was armed with a dangerous instrument.
Your client didn't allocate to a gun, did he?
No. When the court specifically asked what force did you use, he said, I believe he
neck, yeah.
Right. There was no allocation.
So the only thing we have is the RAI. That's all we have.
Yes. And that's what the people rely on in this case.
You don't dispute that there was clear and convincing evidence that he had at least an unloaded gun?
No, I do dispute that.
You do dispute that.
All that the victim saw was part of a gun in appellant's waistband. It was never removed from his waistband. And so while we argue that certainly there's no evidence that the gun was loaded or operable, there's also no evidence on the record that it was a real gun as opposed to an imitation or toy gun.
I see.
Does it make a difference that we're dealing with dangerous instrument instead of dangerous weapon?
Well, dangerous instrument, which the guidelines say is what is applicable here, armed with a dangerous instrument, you have to rely on the penal law definition. And because the penal law definition is an instrument that is readily capable of causing serious physical injury or death, the appellate divisions, all four appellate divisions, since 1972, have consistently found that for a gun, when a gun is the alleged dangerous instrument, it must be shown that it is loaded and operable before.
We have never said that. And
certainly
a gun could be used in other fashions as well, correct? Could be used as a bludgeon. That would fall under dangerous instrument.
Yes. Respondent does argue in the second part of their brief that appellant could have used the gun, the instrument, as a bludgeon or a club. But the could have, I think, is what catches them in this point.
Do the threats make a difference here?
The threats
I mean,
make a difference
if you had
here.
someone who engaged in this kind of behavior but didn't say, I'm going to kill you or I'm going to shoot you, does that make a difference?
I don't think it does, Your Honor. Under the case law,
it certainly does for the victim's perception of what might happen.
Yes, it does. There's no question about that. But I think that's not what the focus is under the penal law definition or even under the guidelines.
Well, what's the purpose of, if armed with a dangerous instrument, why is that important under SOAR?
Under SOAR?
Yeah.
According to the guidelines, guidelines assess different points for forceful compulsion, physical injury, or armed with a dangerous instrument.
Right.
The guidelines do not link the increase in points to an increase in a risk of recidivism. They link it to the harm that could be done. And I think that's why they chose.
Yeah, but what I'm saying is the intent or the spirit of SOAR, how does it coincide with, you know, having that dangerous instrument that maybe could be used as a bludgeon or a, you know, some.
I think it goes to the harm, and I think that's why the.
So if you have it and you keep it in your waistband, it's okay, even if you threaten a lot.
Well,
I'm going to kill you. I'm going to choke you. Whatever it is.
The SOAR guidelines refer specifically to the dangerous instrument as defined by penal law.
Right.
I think, you know, this
They
court has
say
said,
armed with a dangerous instrument. They don't say it has to be used.
Right. They say
If this was a loaded gun and he had it in his pocket out of sight the whole time, he still gets the 30 points.
No, it has to be used or threatened to be used. It's armed with a dangerous instrument.
Under the robbery statute, it has to be used or threatened to be used. Under the SOAR guidelines, just say armed.
armed with a dangerous instrument, but a dangerous instrument is an instrument that has it is used or threatened to
Under the
be
circumstances of its use. So you're saying that someone who comes with a M16 strapped to him, but never brandishes it, is not armed with a dangerous instrument? That sounds like an odd use of language.
I think if it's not used during the offense.
The guidelines don't say it has to be used with the offense. This has to be. I understand that an instrument is dangerous or not, depending on its use or the way in which it's used or threatened to be used. But aren't you going a little far to say from that if it's not used or threatened at all, there's no dangerous instrument in the room?
I think under the penal law definition, no.
In the context of SORA,
Yes.
where we have a sexual assault or a rape situation,
Yes.
might not the threats and the presence, the victim seeing a firearm, might that not affect how the victim responds in that? In another fact pattern, perhaps the victim would attempt to escape, fight off the attacker, but when the attacker says, I'm going to kill you, and the victim sees a gun in the waistband, doesn't that alter the behavior of the victim? Isn't that what the SORA board is concerned with?
I would disagree with that. The SORA guidelines are concerned with the defendant's risk of recidivism and the harm that could be caused. That's all the instrument goes to. The guidelines chose to arm with the dangerous
I'm talking
instrument.
about the harm, because there could be a potential for more harm. The woman might be more susceptible to the rape because of the threat and the higher risk of harm caused by the presence of the firearm.
I don't think that's where the guidelines are going. And I
Yeah, but
think
if you just threaten and there isn't the gun in the waistband, I mean, there's no distinction between those two situations where you give the same threats and you can't see the gun, and you give the threats and you have the gun. Isn't it, as Judge Graffio says, doesn't that affect the harm or the possible harm?
I think that, this Court has specifically said that courts should look at the plain language of the factor. And the plain language of the factor, I think
It's
that
armed with a dangerous
It's
instrument. So why
armed
isn't
with a
that
dan-
armed?
he's not armed
You
with
have
a-
it and you threaten, in effect, to use it.
I think in the sense we've gone away from what I guess I would consider the issue here is how is it a dangerous instrument? And by statute, it's not a dangerous instrument unless it's loaded or operable.
Is this factor one that we're talking about?
This is factor one,
Which really talks about use.
use or threaten use, but armed with. But I think that
Well, what they say is, if I'm reading this right, it says that a sex offender who rapes at knife point or inflicts physical injury to a victim, poses a greater threat to the public safety than one who rubs himself against another on a crowded subway. They talk in terms of actually using it. And then, of course, they do say armed with a dangerous instrument. I was wondering if, and I've never seen this, I've never seen a defendant respond to these RAIs, but if a defendant in this case said the gun wasn't loaded, would that change the case? If you filed an affidavit?
It's the people's burden to show that the gun is loaded.
But this is not a criminal proceeding, is it?
No, but due process.
Cannot an adverse inference be drawn from the defendant's silence?
No.
Why not?
Because that's an interesting question, but I still think the answer is no, because the defendant has no obligation to say anything at a SORA hearing. They can simply hold.
You don't have a literal obligation to say anything unless you're subpoenaed in any civil proceeding. But but in the non-criminal context, when people don't say something, we can draw the gee, if he had something to say, he'd say it.
But I think that lessens the people's burden of proof. The people have the burden of proving by clear and convincing evidence. They have to put forth evidence at a hearing that the gun was loaded and operable. That they failed to do.
Well, they didn't have the gun. How would they do that in this case? Or would it be your argument that it was impossible for them to prove?
It was impossible for them to prove. But I think that's why the legislature enacted the display what appears to be a weapon for the robbery and burglary statute, recognizing that the people have a difficulty to prove operability when guns aren't recovered. The SORA board certainly could have added to the points not only armed with a dangerous instrument, but displayed what appeared to be a weapon.
Okay,
They
Connie.
chose not to do so.
Okay, thanks.
Thank you.
You'll have your rebuttal.
Good afternoon, Your Honors. Mary Farrington for the people. A gun is a dangerous weapon, whether it's loaded or unloaded, and this Court has said as much in People v. Roden, and the Supreme Court has said that.
Do you agree with your adversary that unless it's actually used or threatened to be used, it's not a dangerous instrument at all?
No, I don't.
So that in your view, the offender who commits a sexual assault with a loaded gun in his pocket is clearly armed with a dangerous instrument?
Yes, Your Honor.
How do you reconcile that with the language, with the definition of dangerous instrument in the statute?
Your Honor, I think the definition was designed to be broad. It was designed to include objects, ordinary objects, that aren't inherently dangerous like a gun is. And it's ironic to me that the defendant can argue that when a gun is involved, there's actually has to be a greater showing than with an ordinary object. If this
Is use of no relevance, whether it can be
It
used?
is if it's an ordinary object that isn't inherently dangerous.
I mean,
But
so
I think
the use of a loaded gun, the potential use of a loaded gun is pretty obvious.
exactly. And then the same is true with a knife. And I would point the Court to the decision in
What about an
Pena.
unloaded gun? Is the potential use obvious?
Yes, because I think there are two inherent dangers to a gun that are quite apparent. That is, it can be used to shoot and used to pistol whip.
How do you know the latter? When does that kick in? How do you know that it,
I think if the circumstances
just that it's there, or is it associated with the threats, or what is it?
I would say, Your Honor, that there are circumstances in which the use of the gun would only be to shoot under certain circumstances, but there are other circumstances in which it could equally be used as a bludgeon, and that's this case.
And yet the appellate divisions don't agree with you.
Well, the appellate division decisions, Your Honor, are all in the context of the penal law. They have required independent proof, and I think, quite frankly, didn't consider bludgeoning aspects until later in a handful of cases.
Is pistol whipping more of a threat in a sexual assault than in a robbery typically?
Well, I think that argument could be made because they are in close proximity. One wants to keep secrecy. It's an intimate situation, and so I do think it's more likely that a sexual.
Very, very few sexual molesters shoot their victims, I guess.
I think that's correct, Your Honor.
And they're more likely to hit them with hard objects.
Exactly. If I might get back to the appellate division cases, Judge Graffio, the guidelines didn't adopt the appellate division cases. And if you look at the guidelines, in fact, in another context, physical injury, it did qualify its statement with reference to case appellate division decisions and possibly court of appeals decisions as well at page 833 of the record. Didn't do so in the connection with armed with a dangerous instrument. I think the intent was to adopt the broadest definition from the penal law. That's what the board intended to do, and that's, in fact, what it did do. The concerns of the appellate division in the cases that my adversary relies on are penal in nature, and they don't really apply in the SORA context.
I have a concern about the quantum proof here. Has to be clear and convincing evidence,
Yes,
right?
Your Honor.
All we have is an allocution by the defendant at his plea where the only force that he allocated to was a chokehold around the victim, right? And then we have the case summary, the RAI case summary. That's all we
correct.
have. Is that enough?
Yes.
And we have no signed affidavit or any deposition testimony or anything of the victim.
This Court has said, Your Honor, that the case summary, the pre-sentence reports are reliable hearsay evidence that are sufficient. These are based on the victim's description of what happened. She was in very close proximity to the defendant.
I think that, pardon me for interrupting you, but I think that's true. But in a situation like this where the judge has it wrong, where he thinks the burden was on the defendant and makes his determination, and then the appellate division affirms essentially without opinion it makes it difficult to sort out exactly what the judge was thinking, even though we now all agree that the burden was on the people.
Okay. Your Honor, I would disagree with you that Judge Berkman thought that the burden was on the defendant. I agree that the paragraph in which she addresses a dangerous instrument is not a model of clarity. But I think what she was talking about, and I think that's clear from her citation to Walker, is that she understood the difference between dangerous instrument and display of what appears to be a weapon. She clearly, by citing Walker, found that this qualified as a dangerous instrument. Walker happened to be a case in which the Court relied on the defendant's statements about having a gun.
We don't have that here. We don't have a defendant's statements about that.
No, but what you have are his
them.
threats. You have the defendant saying that he would shoot the victim if she told anyone what happened, and at the outset of the attack, he said he threatened to kill her.
How do you interpret that where she says this approach would be consistent with the law putting the burden on the defendant to prove that the apparent firearm was not a loaded operable weapon?
I think she's referring to the fact that in a SORA proceeding, the defendant can be expected to rebut reasonable inferences, unlike a criminal proceeding, and I think that's what she was talking about, that she drew reasonable inferences from the victim's description of the crime that the defendant never rebutted.
Well, it's short. She says, defendant argues that he should not be scored for use of a dangerous instrument as there is no proof that the apparent firearm which he displayed to effectuate the rape was operable. It's indeed correct that an inoperable firearm is not a dangerous instrument. The use of an apparent firearm is a serious aggravating factor in the penal law. Indeed, the one case this Court has found in this context holds that the defendant's admission that he used a gun was clear and convincing evidence that he was armed with a dangerous weapon. This approach would be consistent with the law putting the burden on the defendant to prove that the apparent firearm was not a loaded operable weapon. So she's saying the fact that he used a gun is clear and convincing evidence it was a dangerous weapon, and the burden is on him to prove that it was not operable.
I think what she's commenting on is in the SORA proceeding, we could expect a defendant to dispute that as a factual matter, which this defendant never did.
So the presumption, okay.
You're saying that having proved that there was a gun, that's a sufficient, that the people have sufficiently carried their burden, and the burden then shifts to the defendant to disprove that it's loaded?
I think we can certainly expect a defendant in a SORA proceeding, unlike a criminal case, which is why the appellate division cases have ruled differently in the criminal context. We can expect a defendant to rebut inferences that a court is asked to draw from the victim's description of the circumstances. I think there are other reasons why the appellate division held a higher burden in those cases than this Court should here. Obviously, there's a higher standard of proof. It relates to an aggravating element that elevates the crime of conviction to a higher degree of felony, resulting in a harsher sentence and the consequences that fall from that. It also requires the use or threatened immediate use of the gun. Here we only need armed. And again, as I mentioned, the fact that I would never be here in a criminal case arguing to you that the defendant failed to take the stand and testify that the gun was a toy. In a SORA proceeding, there is no reason why the defendant shouldn't be held to do that.
Could you have subpoenaed him?
Excuse me?
Could you have subpoenaed him? Could the prosecution subpoena him and ask him whether it was loaded?
I don't think so, Your Honor.
Why not?
But I'm not sure.
You can subpoena the adverse party in a civil case.
At the same time, there are consequences in the SORA. It's not a clear-cut civil proceeding.
Well, plus, I mean, I assume if you put him on the stand, he'd say no. I can tell you unequivocally.
Yeah, that's the danger of subpoenaing the adverse party.
I'd also like to turn to the bludgeon aspect for a moment, because, again, I think the appellate divisions have overlooked this. Defendant claims that in order to find that the gun could have been used as a bludgeon, there had to have been either the use or an express threat to use it in that manner. But we know from this Court's decision in People v. Pena that there need be no correspondence between the content of a defendant's verbal threat and the instrumentality behind it. In Pena, the defendant threatened to shoot his victim as he had his hand in a bag. When he was apprehended a short time later, the bag contained a knife and not a gun. I think underlying that decision was a recognition that the knife is an inherently dangerous instrument. It didn't have to correspond to the threat because the danger it posed was obvious. We didn't need to look to additional evidence of use or threatened use, and the same should be true for a gun.
Do you know, before your time expires, do they update these guidelines from time to time or not?
I believe they have. I believe the last time they did was 2006.
Okay.
Okay, counsel.
Okay, thank you, Your Honor.
Counsel?
Just briefly, 2 points. The comments that the defendant needed to rebut the people's case at the SORA hearing. At the SORA hearing, the people have the burden of proving by clear and convincing evidence it was an armed instrument. The case law is explicit that an inoperable gun is not, without proof that it's operable or loaded, the people haven't met their burden of proof. This is a legal argument based on case law that only supports the defendant's position. To say that he then has a burden to make a factual argument, I think just violates due process and the SORA guidelines.
The robbery statute and the guideline are worded differently. Robbery in the first degree involves he uses or threatens the immediate use of a dangerous instrument. In the guidelines, the SORA guidelines, it's armed with a dangerous instrument. Do you say those two mean the same thing?
Actually, what I say is actually the guidelines is more restrictive in that he has to be armed with a dangerous instrument, and a dangerous instrument is one that the way it's used or threatened to be used is really capable.
So you have one statute or one piece of legislation that says uses or threatens the use of a dangerous instrument, and another that says armed with a dangerous instrument, and you're saying that the latter actually is harder to prove than the former?
Yes, because the robbery actually consumes the dangerous instrument, and the SORA guidelines add on the arm. And I can also say that since the SORA guidelines ask the courts to specifically look at the penal law, the arguments that this is somehow different and the penal law shouldn't apply is just contrary to the guidelines.
Yeah, but it's odd to repeat some of what Judge Smith seemed to be saying. I mean, to rob somebody, you've got to use or threaten to use. A mere threat works for a robbery one. But you're saying that for a Factor 1 SORA case, a threat is not enough. You actually have to use.
Yes. You have to possess and use or threaten to use.
I just noticed that the robbery statute actually uses armed in subdivision 2. Is armed with a deadly weapon, or uses or threatens the immediate use of a dangerous instrument. Isn't armed a lesser showing? Doesn't armed, just in plain English, do you mean just have in your possession?
I don't think so. I mean, I disagree with you on it. But I also think that, bottom line, it doesn't matter in this case because the whole question still is, was it a dangerous instrument? That is the thrust of our argument, and that it wasn't a dangerous instrument because there is no proof it was operable or loaded, and that he did not use it as a weapon.
That issue might have been easily resolved, or it would be easier to determine one way or the other if there had been a trial. But what do you do in a police situation? I mean, were they to anticipate the issues in the SORA proceeding at the time of the plea?
Well,
to develop the record?
I mean, SORA was enacted at the time of this plea. Certainly the instrument was out there. The guidelines were out there.
Because the issue we're talking about didn't need to be allocated in connection with the plea.
Yes. But so what they are relying on is the defendant's statement that she saw part of a gun in a waistband. And our position simply is that's insufficient to show a dangerous instrument. And it is the people's burden. And clear and convincing evidence is making it highly probable that that was a dangerous instrument.
Okay, counsel. Thanks.
Thank you.
Thank you both.